Supreme Court rulings are complex documents that can be difficult to decipher. The Supreme Court of Canada's June 26th ruling granting land title claim to the Tsilhqot'in First Nation is no exception. A panel discussion was hosted in the Gathering Place at CNC today to start a discussion about what the ruling means and how it could play out here in BC.
Carrier-Sekani Tribal Chief Terry T.G. called the ruling the most significant First Nations legal case in the history of Canada. A crowd of well over 100 people came to CNC to have an open discussion about the Supreme Court's decision to grant land title claim to over 1,700 kilometers of land to the Tsilhqot'in First Nation.
I think it was really important to begin the dialogue right away.
Marlene Erickson, Acting Director of Aboriginal Education at CNC, organized the panel discussion because in the weeks since the Supreme Court's ruling, more questions have been raised than answered.
This, of course, is a legal decision, and we know that legal decisions are interpreted in all kinds of ways.
The panel included leaders and members of local First Nations. All shared their perspective on the Supreme Court's ruling. Lawyer and activist for Aboriginal women's rights, Mavis Erickson, said the ruling means a new day has dawned.
Development isn't going to go ahead quite as freely and quickly as it has been in the past without considering Aboriginal rights and title.
The June 26 ruling came down in the wake of the federal government giving the green light to the Northern Gateway pipeline. Today's panel feels projects like this one will need more than just consultation with First Nations, but also consent.
With Aboriginal title now being declared in the Tsilhqot'in territory, that creates a bigger burden on the provincial and federal governments to justify infringement into the Tsilhqot'in territory.
However, the message from today's speakers was that First Nations will not be putting a halt on resource development, but will consider sustainability of a project before consenting to it.
People need to understand that the legal landscape and the political landscape has changed, that First Nations do have a say in what's happening in their territories.
While there was a great deal of dialogue at today's panel, there were still questions left unanswered. No light was shed on the loophole that exists within the Supreme Court's ruling. If a project does not receive consent from the First Nation, the government must prove it's in the best interest of the country while fulfilling fiduciary duty to the First Nation. Panel members were unsure of exactly how that aspect of the ruling will play out. Victoria Levy, CKPG News.